United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay.
Can we do roll call?
Yes. Can you call roll, please?
Sure. I need Member Hutchins,
Here.
Member Hennigan,
Here.
Vice Chair Carey,
Here.
Chair Marsh,
Here.
Member Brenner,
Here.
and Kaczynski and Rodriguez are absent for the record.
Okay. Is there anybody here, I'm sure, that needs to be sworn in? Can we, if you're going to present or speak on any subject?
All right, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
When you come forward, please state your name and address clearly for the record and whether or not you've been sworn in, and please speak directly into the microphone when they call you up.
Okay, moving on. Is there any public comment this morning? Not today. Wow. That's a change. Okay. Hearing none, let's move on to the discussion items. The first project is a development plan which for 21 Hudson Avenue. This is a quasi-judicial hearing, and I'll ask any of the commissioners to please share if they've had any ex parte discussion.
None.
None. None. Okay, is the applicant here? Yes. Please step forward. Go ahead.
Good morning. My name is Harry Roush. I'm the owner of PBG Homes, and I'm seeking approval to build a new single-family house at 21 Hudson Avenue. It's a 5-bedroom, 6 full bath and 1 half bath house, 4,413 square feet of living area, 5,327 square feet under roof. The impervious area percentage is 34%, which is much lower than the required maximum. The architectural style is late century contemporary with some elements of Bermuda colonial, which fits the description of many of the residences on the street. The roof will be standing seam metal, which is the type roof that most of the new houses on the west end of Hudson Avenue are using. The elevation of the house is a median of about, most of the houses on the street, about 25 feet above the floor level. The architectural of the subject is for the most part symmetrical, with all components being in balance. Construction is CBS, concrete block, and the colors are in a range that is compatible with those homes in the area. One of the things I know the town is particular about is shielding the mechanical equipment on the side of the house. This equipment will be shielded from the street because the back of the garage juts out 7 feet, and on the west end, it will be shielded by shrubs, silver buttonwood shrubs and dwarf clusia shrubs, which can grow up to 15 feet. Probably won't go that high, but they can. So that's about it. I think the house will fit in nicely and will complement the town.
Do you have any professional representation here, architects?
Here?
Yes.
No.
Okay, thank you. Okay, any comments from the commission?
Yeah, my question is, on the east side of the property, there's an existing retaining wall.
Yes.
Uh, Will there be a retaining wall built on the west and south side of the property?
Yes, the town engineer has required retaining walls on the south and the west.
You know, because looking at the landscape plan with the 2019 date, that doesn't reflect a retaining wall. So the landscape plan is, I'm pretty sure it's showing sloping off on the, and in 2019, you probably set this building at a lower elevation than we're requiring
No.
today.
The elevation was always the same.
Okay, so just, it's an oversight on the part of the landscaper that he's not showing the retaining wall?
Yes, it wasn't required at that time.
Right, so if it wasn't required at that time, the landscape plan doesn't match.
Well, I don't think the landscape plan reflects the grade. That's the only thing that might change.
Can I just point out one other thing, Rick?
Go ahead.
Your survey obviously is not being updated for the property. You have elevations here that are the level with the road, 2.3. And obviously that lot was filled over the last couple of years. So your survey, I just want to point out to staff, unless there's another, there's only the empty lot survey, which we have here. And it was done in 19, I think, or,
But it was updated.
well, it was, the elevations are not correct. They can't be. Because that lot has substantial fill on it. Can I ask Tara, have you got a survey that shows, doesn't have a sheet number, but it says empty lot survey?
Yeah, the lot is vacant right now,
Right.
and it was filled.
The survey we have here, or I have here, says it's +2.
Well, it was adjusted in December 22. On the right side, it says that. Adjust to NAVD 88.
Well, if the street's at 2 point,
And these are NGVD elevations,
Yes.
yes,
so it's
And
about
A- and A-
2.5 lower.
oh, I know.
This is
I'm just-
NAVD.
I'm just looking at relative to the crown of the road.
Right, so the Granite Road is 512 or 22 and 504, so it's actually 3.5.
But look at the lot surveys as existing are saying 2.77. Unless I don't have, I have a Principal Meridian Surveying, Inc. Is there another survey?
Is
Sorry,
it-
Rick, I just,
No, that's the same question I had.
Can you see what the date is on this? Yeah, you don't have the current survey. That's the survey, the lot is vacant.
yeah, it shows a vacant lot.
No, that's the septic permit. You gotta go back.
Keep going.
You're going the wrong way. There it is.
The site drainage is correct. It looks like it's been corrected, but the survey of record is, it just can't make sense because it shows 2.27 and then on your drainage, you show it at 9 point something. Or the grades are now up in 7.
Talking about on the drainage plan?
Yeah, your drainage plan,
That's finished. This is as is.
I can tell you, sir, I live on that street and that lot is higher than 2.7. I'm just,
So what, can you just, like, describe a number what you're comparing.
Well, I'm looking at this survey. It's
Right.
part of our package here.
Yeah.
And it says boundary and topographic survey. And if you look in the middle of it, middle of the lot, it says 2.77 plus. Have you seen the same thing I'm read?
Yeah, I do. I had it marked. I had the 2.54 next to the 2.77.
I just,
Well, a lot is scooped out, you know, it's crested on the sides and low in the middle.
yeah, but it
For
doesn't
drainage
show,
purposes.
it doesn't show even on the cresting or the berms. There are only 3 point, gosh, it's so hard to see. I'm just suggesting that you know, your drainage plan seems to work based on some more accurate information.
Well, it's done by the
What's
engineer.
submitted here is not correct, or can't be correct. So for staff and for permitting, I think I'd like to have a more, or suggest we have a more updated survey of as-built, or pre-existing, I should say. You see what I'm saying?
And that would tie into the need for retaining walls and how high they are too.
Correct.
Typically, we see an elevation from the side showing the retaining walls, so we have some sense what the neighbor is going to see. Do you have an idea of what the west retaining wall height will be?
Yeah, they're both about 6.55 feet.
And will they have a fence on the top of them?
No,
I think that's our code.
is it required?
You'd have to ask staff, but
Well, if it's required,
see,
then
yeah, I think if you look at your neighbor to the east, there's a fence along the retaining wall. Anyway, that'll come in your detailed review, but
So-
we're concerned always as to how it affects the neighbor and the impact on that.
Sure.
So basically, he's going to have a 6-foot wall along his east elevation. Is that correct?
Yes.
Sorry, I didn't mean to interrupt, I just wanted to.
Go ahead.
Any other comments, Steve?
It's just as a more difficult package of documents than we normally see, and the dates don't all synchronize. And we just want to make sure we know what we're getting before we make a decision.
I have just one question that doesn't regard the elevation or anything else, just looking at the plan in general, which I think it's a nice-looking house. I'm looking on the east side of the house where you have a living room and a media room with a bar.
The first floor?
Uh-huh.
Yes.
And the one thing that I observe is there's no natural lighting on that side. Is there any reason for avoiding windows? This is a question. It just would seem that you would want to have the opportunity to get some
Well,
natural
the
light.
windows are in the front and the back. I thought that would be a nicer view than looking out at the neighbor's house.
Well, I'm just thinking of the light that comes in, because if you're only relying on light from the north and the south, you might not be getting as much light in the room as you would hope.
Well,
But
you
that's just a thought.
Well, you got plenty of light on the south end, but the north end, I agree.
Just a thought. I'm not telling you how to design the house. I'm just
It was just
curious about
mainly
that.
for usability in the room, giving more wall space.
Yes, sir. I think there's also another concern we have is that we're trying to discourage all these blank walls. And on, properties that face adjacent neighbors. And, yeah, to that point, I think we would recommend that you at least interrupt that lower level with at least 1 or 2 windows to break up that, very solid mass that you show. And to improve on what Mr. Hutchins has just said, it would actually make better use of that space from a lighting. We can't tell you that, but we can suggest, and we are now requiring that these blank walls have some kind of fenestration to interrupt that mass, primarily for the neighbor's sake.
Mhm.
So we'll make that a condition. Well, let's get this in some kind of order here. Neil, have you got any comments?
I only have the same comment on the, I guess it's
The east
left
of-
side east elevation, the lower level blank. That's the only comment I had on the design.
Rick, have you got any?
No, that would be my primary comment. I can't tell from the landscape plan whether that it offsets that, but I think we would want to make that a condition for staff to be satisfied with the east elevation.
Okay. Roger?
Well, it might be useful just to let you know that in some other homes where they had to put a large retaining wall and they didn't want to put a fence on top to make it even higher, what they did was use a terracing thing where the first retaining wall was maybe 4 feet, and then there was a grassy area, and then another one, and you get to the same height with a little grass area between. It breaks up the view for the neighbor and avoids the need for a fence, I believe. Is that correct?
Yes.
So it's just another alternative.
David, any more comments?
No.
Okay, no, I think it's a very appropriate house. I think the scale and the selection of materials. What is the color of that metal roof? I couldn't find that anywhere. You've got a sample listed, but it has no color.
Color is sort of a medium gray.
Okay, that's fine. Okay, and I assume, is this a speculative home, or is it?
Yes, it is.
It is a speculative home. Okay. All right, without any other comments, anybody wish to make a motion?
I'll make a motion for approval, subject to the comments by staff and asking that it be conditioned on a revision to the east elevation to break up the solid wall on the first floor.
And the site survey corrected with the retaining wall shown, or?
I don't think we have to make that a condition. I would think that's something we're pointing out to staff to.
Okay.
Okay. Second?
Second.
All in favor?
Aye.
Aye.
Thank you.
Approved?
Yes,
Thank you.
Go
with
Bills.
those conditions. Okay, moving on to number 2 on the action list item. Discussion of the proposed code amendment to 64-1/modification of ordinance 2005. What I'd like to do is maybe ask Christie to introduce this, or Lynn, whichever, or to bring the commission up to speed as to where.
Okay. Thank you, Chair. The item for discussion today has sort of been developing for some time. As you may recall, this issue of the properties along Old Ocean between Anna and Corinne Street. All of those properties in that area, except for one, have some issues with compliance with the RSE zoning district in terms of total lot area and lot width. This issue came to light recently when the owner of 6073 Old Ocean came in to apply for development review. And it was discovered that to develop the structure they desired, they would require 5 variances. So they were directed to go to the Board of Adjustment to pursue the variances. They pursued the variances. The Board of Adjustment denied the request. Now, the request for variances, obviously, you have to look at the entire request. But what they did do was 2 of the variants, which deal with total lot size and lot width, they were denied without prejudice, which means that you don't have to, if you're denied a variance, you have to, by code, wait a full year before you can reapply for a similar variance. So by denying it without prejudice, it allowed that property owner to come back sooner should they desire to seek those same variances. So total lot size and lot width were denied without prejudice. The rest of the variances were denied. That case is currently with the circuit court because they did file a petition to challenge that denial. So that's with the courts. After that happened, the property owners, through their attorney, pursued a provision in the code that allows them to propose a text amendment to the town. And as you may recall, that text amendment initially came here for this board's consideration, which denied it. It then went to the town commission, which first considered it at its March meeting, I believe. The April meeting. At the April meeting, the town commission denied it, but pursuant to this item, sent it back to this board to look at it and to really look at it in conjunction with Ordinance 2020-05, which 2020-05 created arguably some of the issues that the properties on the east side of Old Ocean area are facing, because one of the changes that's clear in the Ordinance 2020-05 was it restricts usable area for purposes of determining your FAR and your total lot area. And what it said was, even though all of the parcels owner on the east side of Old Ocean, technically their property extends out almost to the edge of the water, beyond the knee-high water line, the 2020-05 ordinance said for purposes of determining lot size and floor area ratio, that area between the mean high water line and the 79 coastal construction control line cannot be considered as essentially part of their lot. So the impact to that, while I'm not 100% sure, because there was previously an impact on usable lot area that existed in the code before that ordinance, it shrunk their lots in terms of their lot size and the floor area ratio. That's one of the major things that ordinance did that impacted those properties on the east side of Old Ocean. For the properties on the west side of Old Ocean, it doesn't look like the ordinance had much effect because those properties, all of them except for the most southern one, already were constrained because they didn't meet the requirements of the RSC district in terms of minimum lot size and minimum lot width. So the question posed by the town commission was, should the town consider repealing Ordinance 2020-05, or is there something between what was proposed by the one property owner and a total repeal that would work better to resolve this issue of every property except for one in this area having to get variances if they want to redevelop?
That's if they want to do a tear down and rebuild, but if they build on this existing footprint, they are grandfathered?
It gets a little bit difficult because what we believe, and this was the research we've only done really for the one property 6073, was it used to be that most of these properties were owned jointly, the property on the west side of Old Ocean and the properties on the east side of Old Ocean. So purposes of redevelopment, they had a lot more lot size to, play with. What happened, we believe, is over time, and we know for sure on 6073, that they went to the property appraiser, got a separate PCN, and sold off the property on the east side of Old Ocean. So now the two properties were owned by two different property owners. And while there may have been some issues with the RSE district at that time, now the issues are even worse because now you've created two smaller lots. So for 6073, to make things even more complicated, it's not a legal lot of record because they created an even smaller lot in the RSE district when they sold off the property on the east side. So technically, 6073 is not grandfathered in because they illegally created another lot that's smaller. So they're not grandfathered in. So at a minimum, for Mr. 6073 to redevelop, they need the lot, total lot size and lot width variances, even if they redevelop to their current footprint. If they obtain those variances, there is some language, which I believe Mr. Hutchins has provided us, that would allow for them to build up to a max FAR of 0.45. And that's an existing overlay that's in the code.
Could we take this topic and carve it down into some blocks that may be
Probably a good idea.
resolvable? And one of them I would suggest, I've sent some information out, distributed it. Can we redefine RSE and RSF to make everything in the town conform? So what I'm going to say is, why does the initial definition of what we're dealing with, RSF and RSE, even have a size number in it for existing properties? Until you take that number away, these lots will always be, never be lots of record and never will be conforming, okay? So there's no way to make the lots bigger, to stretch them width or size. So they are zoned, they are recorded as RSE. There aren't going to be any more RSEs unless they're created out of an existing one. So the information that I gave to you states that if it's RSE now, no matter what the size, it's okay. It's as existing today. If you subdivide any future one, then at that point we impose the 20,000 square feet. So that takes the lots that are in the 50,000, 40,000, whatever. It precludes those people from subdividing into smaller parcels than what we originally did intend, which was 20,000 square feet. But we also have 4 lots that are in RSF that are just slightly under 10,000 square feet. So they have the same dilemma, although the width is not an issue on those lots. So if we just take that 20,000 and 10,000 feet out of the definition of RSE and RSF, those lots can be made conforming by demanding what would happen to a future lot and by stating what the setback requirements would be based on these new sizes, and that's what I gave a range of those in the proposal that I sent out. So the language there is to bring all the existing lots into conformity. I don't know how you make them lots of record, if that's a technical thing that legally the town has to do. But at that point, we're not arguing over size. We're just dealing with what, in fact, we have.
What do you use to calculate?
That's a whole different subject matter,
Well,
because
that's
that's going to
important.
affect the FAR.
Right.
But changing the definition of RSE and RSF, I don't see how we deal with it any other way. We just have to state that what's zoned RSF now, what's zoned RSE is in fact those, don't let them be made, carved smaller than what we've always intended again. So that will stop creating more of these problems in the future, but we have what we have. And please take a look at what I proposed. And the language, I just don't think it's that complicated to get this out of the way.
I would like to throw one more into Neil's. If we like Neil's idea, I would suggest that we move these 16 lots into the RSF zoning out of the RSE. And then we don't even have to talk about RSF in this discussion. Because these 16 lots are more similar to the ones to their south. They seem no longer to fit in the RSF after they were all split and became smaller.
Mm-hmm.
The RSE, rather. Just another thought, and that then gets us away from making any modifications to the RSE, because if you followed your suggestion, we'd do it only to the RSF.
Well, we're going to have to deal with, we're going to have to deal with both of them, correct?
Not if you
Because
moved,
there's
made
there's non-conforming RSF lots right now.
okay. Other than these.
RSF, not RSE.
But
And there's more RSE lots than have been listed by either Mr. O'Gorman or Mr. Pappas's attorney.
Okay.
There's a couple more.
So this is this language.
No, not that, this one.
Yeah, I'm trying to find.
It's titled RSF Non-Conform Resolution.
I don't think all of us got that. Was it in
And-
the package?
I handed it out.
There's only-
I gave you a handout. There's one if you need one.
Yeah, I don't.
So there, you have
I
one
got
now.
a handout from
Okay,
Dave and
so-
this other
okay,
handout.
So
I
so
don't
there
have
it
one
is.
either.
And then within the RSE, non-conforming lots,
Okay, I got it.
we look at whether they're, how they break down, because some of them wouldn't even conform to RSF criteria because they're only 55 feet or 70 feet wide. So I've subdivided those, and for the smaller lots, I'm giving them the setbacks of the Ocean View District. And only modifying the Ocean View in terms of whether there's coastal control line impact. In other words, if they back up to the ocean, then the rear setback needs relief.
So we're changing the whole classification from RSC, or proposing RSC to RSF.
RSE would have two categories underneath it, correct?
What's the second one?
It's based on lot width.
This seems a little broader than what,
The,
I understand from Christie, we were asked to look at ordinance 2005,
Yeah, that's, we're stepping,
and,
well, you have to get rid of nonconformity. How else can you do anything on the lot? Then there's no reason to have to deal with, from this particular standpoint, there's no reason to have to deal with them one at a time. They're
So,
all brought into,
so you're, let's just, I'm trying to follow along. Let's just consider the 8 lots, realizing there's other non-conforming
correct?
lots.
Go ahead.
You would suggest taking them out of RSE and putting them into RSF?
No, I would leave them as,
Or you want two classes of RSE?
I would leave them as, they are what they are. They've got dimensions, correct? We
They-
still haven't talked about what's usable because that's a whole nother subject. But they have dimensions. They've been surveyed. We know where they are, what they are. Just say they're RSE. Leave them as RSE. Then the only time you look at them as in a different category is when you look at the setbacks, and that would be based on the lot width. Okay? The setbacks for RSF and let's go back to a chart that we had at a prior meeting. The setbacks for RSE and RSF are identical. Okay? So I'm doing exactly what Rick is saying, where if the lot is greater than 80 feet, it will have the same setback requirements as an RSF lot, which is the same as an RSE used to be. And for 80 feet or less, we're giving relief, which I think when we had the discussion at the prior meeting, there was consensus to give some relief, but
Sure.
it was whether it was given in the form of everybody coming and getting a variance every time. I'm saying we don't have to do it. It can be done globally.
I guess the question to either Corey or Christie is, how long is this process, if it was to be adopted, or whether it could be adopted?
Well, I think what we'd have to do is we have to look at the comprehensive plan, because I don't know how much of the specifics for each zoning district is within the comprehensive plan offhand. I don't know if Corey does. So it may require a comprehensive plan amendment. Then obviously it's a rezoning because you're reconfiguring the minimum requirements for the zoning district. So you can pursue those concurrently. So it's an ordinance process, which would require the drafting of an ordinance, bring it here for this board to review, and then 2 hearings before the town commission.
And we would need town commission direction to do this, correct? Yes.
Yeah, because, I mean, right now, what they're looking for from this item is a recommendation of, really what to do in this area, so.
Well, my recommendation is make the lots in town conforming and make them lots of record because they are now conforming.
Well, I'm just concerned about a comprehensive plan. That's what
And that
the impact it has.
compatibility you'd have to look at.
One issue that I did bring up with the town commission is I believe our ear-based amendments for the comprehensive plan are due in 2024. And by code, this board is charged with, reviewing the comprehensive plan annually and determining what changes and updates need to be made. So if there was going to be a change to the comprehensive plan, one thing would be to consider making that part of the ear-based amendments. But obviously, that's a much bigger lift.
I've got a question, getting more directly back to these homes that are in that particular neighborhood. Thanks to you, I was brought up to speed on 64-7, and I think that might be a good place to start for these people to build. They're not allowed to build beyond the CCL, period, right? Although that, if you're sitting on their back porch, it looks like a yard. So I don't know whether you would include that entire amount for this 45%, or if that would take them over 7,500 square feet total. But it seems to me that we could probably work around it.
Right, so there's two different approaches. So I believe the first approach that we were discussing was how to make these lots conforming.
Mine has nothing to do with the FAR of the lot.
Right, and so what Mr. Hutchins is addressing is really addressing the usable area, which
You pointed out is
dictates the FAR. And
Undefined.
so they are almost two separate issues, because the one issue is to bring everybody, okay, now you're all conforming. But now let's set the development parameters in terms of how big can you build on your now conforming lot. And so that's what the separate issues are being discussed.
So I think we have to have a discussion of what have we historically used for lot size, not saying what kind of lot size, when we have done development plan review. And I can think of, I believe when we did Whitney Way, there was some environmental or some impacted land in the back of that lot, and we excluded that when we did FAR. Is that not correct?
Yes, sir, that's correct.
So whether we're going to include all surveyed land size or however we're going to define that, I think that's a serious discussion.
The problem I see is, as mentioned before, that these are not grandfathered, or this lot is not grandfathered. So it doesn't have the flexibility of some of the criteria to relax, and go through the Board of Adjustment and have reasonable reductions or maintain certain non-conforming items that may be existing. That's traditionally the way I've seen it, where you've had grandfather rights, and you can say, I'm gonna maintain the same setback that's non-conforming and develop accordingly.
Mm-hmm.
And that, historically, I think in the town or most other towns, and I keep repeating this every time, that's usually the process, rather than changing the overall zoning criteria. Because as I mentioned, the comprehensive plan is impacted. It's not something we can just randomly do. It has the whole process. So, I think we have a very unique situation here, but it's grandfathering or what's deemed reasonable by this commission, knowing that they don't have the land area to do what they're, or the developing land area to do what they want to do, but
Well, as I handed out another handout, and I think we have, and I was having the discussion with, trying to give the attorney a heads up here at the beginning of the meeting. We have to come to some resolution as to where the town has precedence and where the state has precedence in terms of the Florida statutes, and what the state is permitting the town to either modify or include or exclude, I think is, I'm not certain from the things that I have read, and obviously I'm not an attorney, but I just don't see that we have a clear expression of where things are calculated from and what things are permitted in terms of when the state will allow you to, clearly they will allow you to rebuild if your property is destroyed, but when will they let you rebuild and remain on that footprint? Is redevelopment something that is acceptable, or if it's acceptable, how do we, then calculate what area it's acceptable on, ours versus theirs in terms of the state. I see in our documents that we take reference from the mean high water line, and in 160.1052 of the Florida statute, it talks about the mean high water line plus 50 feet. And so who's right?
Let me just clarify one thing. The state DEP,
Yes,
they will allow you to build eastward or seaward,
okay,
as long as you structurally meet their criteria.
right. So that's the second topic, which is coastal armoring, correct? So if the seawall that has been put in on these 8 properties meets the definition of a 100-year
Yes,
coastal armor barrier, then they should be able to put at least uninhabitable structures all the way to that barrier, correct?
within reason. It's not, and I say that because you're dealing with government agencies. It's, you can't build on the wall, obviously, but you could have a pool, you could have a deck,
That's what I'm talking
but
about.
they're all frangible and they're washed away.
Expendable.
Yeah.
Okay. So whatever revision we make, can we reflect that in, specifically state that in our reworking of whatever we're doing, that,
My point is that dealing with DEP, it's a lot more flexible than an ordinance from a municipality in terms of land use and development options. Because as I said, as long as you satisfy their structural and hardening criteria, you can get relief quite easily.
okay?
So,
I want to go back to Christie's introduction and ask a question. I think the question was, should we consider repeal of 2020-05? And not that I'm advocating that, but what I want to understand is the implications of if it were repealed. What would then be the measure of lot size on these specific lots?
you'd have to develop.
How would that, I guess, how was it determined before
That's this.
2020-05?
Yeah, I think there's several issues. If you wholesale repeal 2005, there's a provision early on in the ordinance that was struck out that I believe defined usable lot area based on your septic field and where you could and couldn't build based on that. That was struck when they passed 2020-05. So then they added a provision on usable land, and usable land really only became applicable to the properties adjacent to the ocean. And that's the provision that then struck from usable land between the mean high water line and the 1979 coastal construction line. So that really didn't change much because I believe to this day you still can't build in your septic area, but I don't know that that's figured out when they look at FAR. It gets even more confusing when you start looking at our definitions of FAR, because technically our definition of the floor area ratio is based on your usable lot, but then when we have it in our zoning code, it's based on total lot area, which are two different calculations. So it's very confusing, and it's not clear in our code what really is to be used to determine your FAR. Is it the total lot area or is it only the usable lot area? Because ideally, you can't build in your setbacks. There's some easements you couldn't build over. You can't build over your septic field. So your FAR should be a more constricted number and not really based on your total lot size, but it's however you want to define in the code, and right now it's kind of inconsistent. So what I'm saying is if you repeal 2020-05, I really don't know, unless you make other changes to the code, how you calculate FAR based on our current definitions. And that's kind of more, it gets into our item dealing with the FAR, because in my mind, it's a little confusing right now in our definitions. So that's one issue. The other issue is, the 2020-05 dealt with the CCCL. And from my read of it, and I'm certainly not an expert about CCCL and the state permitting process, but my read of it, it looks like what the town did back then was it said, okay, Palm Beach County has adopted the 97 CCCL. And so that's what the town adopted, and it made it similar to the state statutes for when you build beyond the coastal construction control line. So it allows you to develop beyond the 97 coastal construction control line with some requirements similar to DEP on permits. The 79 coastal construction control line was really adopted as your rear setback line. And the only way you can build beyond that in the town is if you get a variance. So you'd have to show a hardship. So I believe what they were trying to do with 2020-05 was to say, okay, we're accepting the 97 as our coastal construction control line, but we will allow for some development just like DEP does. 79 is our hard stop unless you truly have a hardship. So repealing that would repeal those, and then we would be really kind of left up to the state statute, which may or may not be good or bad.
Right. So there's two aspects of the 77 that seem to apply here. One is that it becomes the hard setback. Seems reasonable enough. Then the other portion is that it also determined lot size, which really seems to be at the heart of where some of the issue is. And if we could redefine how lot size is calculated, not using the CCL, and leave the rest of 2020-05 in place. Now then, can it be done less than globally? Can something be changed on how the lot size is determined on these 8 lots without creating a domino effect up the coast?
Well,
Right, and I think that's one thing to look at, because if Kelly, can you have access to the current zoning map to show the whole RSC district? Because the usable lot provision that was added for the 2020-05 ordinance really impacts the properties adjacent to the ocean. And for these 8 lots adjacent to the ocean between Anna and Corinne Street, it really impacts them. So to your question, you could address just usable lot area for those 8 parcels.
if we make the 79 coastal construction line the rear setback limit, we're denying the use of everything from the coastal construction line to the armored barrier, correct?
Correct.
I don't think that's,
So that's reasonable.
pardon?
Isn't it reasonable?
Is that reasonable?
I think we had a sketch from
I-
the
I-
petitioner here
They're
last
gonna have
month
no
or the month
lots left.
before that said, that showed houses being built up to that, but
Yeah.
Because
I didn't bring it.
Because the state does say that if you armor, they're implying that that is usable land under 61.053.
Not eastward of the CCL.
Pardon?
Not eastward of the 97 CCCL line.
79 or
79, 77. 77.
79.
77.
79, sorry.
79, 97.
79, I know it well, 79, sorry.
I mean, read, this is verbatim from the state ordinance.
If I
The
was,
department shall exempt construction proposed for a location seaward of a coastal construction control line and landward of existing armor for certain siting and design criteria.
if,
This is not, this is for the 95 line, not for the 79.
if I can make one
I couldn't find where it said that.
Well, that
comment.
would be the current
This-
CCCL line.
If I was living in one of those 8 lots, and I was looking out at the backyard, in my mind, the backyard would extend to the armored seawall that I spent a lot of money creating, so the whole thing didn't wash down into the ocean in the first
Absolutely.
place.
Yeah.
So, I realize we have a 77, 79, whatever,
79.
but I don't know that that should be limiting. It-
But when you look out in your backyard, your setback line is inside of that backyard. You can't build to the edge of your property.
could you establish a setback from that seawall?
Well, that's what
Well,
we're
we're-
talking
we're
about,
talking
possibly using the coastal construction line as the setback.
Yeah, but that's quite a bit different than just a regular backyard setback.
Absolutely.
It's half the lot.
Or more.
And
Yeah.
if you do recall, one of the things in the proposed text amendment was to allow for construction beyond the 79 coastal construction control line up to the seawall. And it was for these non-habitable structures, and specifically they were talking about a pool and like a sun trellis type of thing. And I do believe that would also be allowed by DEP. But, and so that was one of the things that they had proposed for that text amendment to address that issue. What I asked the clerk to put up on the screen is the current zoning map. And if you see in sort of that mustard color, that is the RSC district. And so the properties we're talking about are the ones that are just at the southern end of the RSC district.
Right.
So you can see how, you know, it would have made sense way back when these zoning districts were first established, if these properties were jointly owned, that they would be considered part of RSC. But now, for the most part, they're not, and so it creates an issue because they are closer to the RSF, but they still wouldn't be compliant even in RSF, unless you adopted something like what's been presented or an ocean view type of overlay that would address these smaller lots in RSE.
Well, it shows that by separating the lots, you've created a unique
Mess.
It's a conundrum.
It's simple as that. I mean, I think from what I'm hearing and agree with is that there's obviously, or hopefully, methods of giving some relief to those owners. It's just the method, and I guess, you know, we rejected the overlay district because I think you know, it's difficult when you make your own criteria, as was presented to us.
It had unintended consequences.
Correct. But I think going back onto listening to the Board of Adjustment meeting back in September, I guess it was, you know, the two items that were approved or denied without prejudice were basically the two that we're talking about now. So I think there's got to be a way we can find to, you know, come up with a formula to give these parties some relief without convening or contravening, you know, some of the DEP or even some of the other town ordinances. So I'm open to suggestions. I mean, I know you've got one, Neil. I don't know if staff, Corey, do you have any opinion on this discussion?
Mr. Chairman, I think a lot of the ideas that have been brought up are worth considering. One of the things that Mr. Hennigan suggested, I think, is considering setbacks, for instance, from as a percentage. I think that's sort of where you were going in a way, where the minimum lot size or minimum lot width in the RSC is 100 feet, and if you have 15 feet on both sides, so that's you have a side setback of 30%. That may be a metric that you could apply to smaller lots in looking at the development. I think he's also suggesting that because these lots have existed, whether they were created contrary to the code or not, for quite some time. Homes have existed on those properties for quite some time as well, and the town, either prior to the zoning going into effect or subsequent to zoning going into effect, have issued permits for homes on those lots, whether they were at the time known to be not lots of record or not. So that I think what Mr. Hennigan is suggesting is it at least makes sense from a perspective of some other communities that I've seen where you have nonconformities that have been created over time, to try to find a way of enabling them to be conforming, and perhaps some of that could be done through the development plan review process. I mean, it could be that one of the things that you mentioned about using the armament as, say, the rear lot line from which you measure a setback, that certainly seems to make sense if you use the analogy of a seawall. If your lot goes beyond the seawall, I don't think you're measuring your setback from the home to the lot line. You're measuring it to the water line. That's how at least the Ocean Ridge Code defines it. So I think some of the issues that are being presented could be addressed through some code amendments. I think the point is very valid to confirm that there is no conflict with the comprehensive plan. But I think a lot of the discussion that you've had this morning is consistent with some of the other codes that I've seen when you're dealing with situations where the existing development pattern isn't consistent with the regulations in the code. And there are also other codes that I've worked with where in some cases you have to go for variance to allow for certain adjustments in code requirements. There are waiver provisions, for instance, or as you know, the town adopted the allowance for administrative variances for some minor setback deviations for existing non-conforming structures. Something like that might be applicable as a waiver that could be approved perhaps by the Planning Commission in a development plan review process. So I think there are certainly issues, as you said, in a lot of ways that this is sort of a mess. And there are several primary things that could be addressed: the lot size, the lot width, perhaps through code amendment, and some of the other issues might be addressed through development plan review.
Thank you. We're spinning around. I think we're all, I assume that we're all in favor of some relief.
Yes.
Yes.
It's just the method and means that we can achieve it. I mean, Corey pointed out a couple of things there, or two routes. Variances, administrative variances are a little kind of dangerous, I think. I don't know if Christie has an opinion on that. But, you know, I wish we had grandfather. These lots had a grandfather status. I mean, it would make it a lot easier to grant some of these, you know, variances with conditions. So,
Well, it's where we go next is the question.
Yeah.
This is, I think this is more complicated than for us to be able to sit here on a Monday morning
yeah.
and come up with the magic solution to it. It's going to require some iteration with staff time, and what I would suggest is that we have our best brains on staff, both consulting staff and town staff, to noodle with this and come back with maybe an alternative or two or three for us to focus on without writing it up into an ordinance. I would favor not repealing 2022-05. I'd like, but modifying, yes, getting relief on the setbacks, maybe redefining what the setback is, land areas. These are all options that are good suggestions, but we need to kind of focus it. If there's a need for this group to get together with staff in a workshop, I'm sure we'd be happy to do that. And sometimes the workshop's a little more informal and easier to have some back and forth. But that would be my suggestion. And I know it doesn't give us a nice solution to take to town commission for next month, but I think short of repeal, we don't have a decision that could be made today, and I don't hear anybody saying repeal is a good idea.
I want to ask a question to our attorney. What are the downsides if we repeal this ordinance?
I think the biggest downside is, that what is currently in place for your coastal construction control lines, it appears that by repealing, you may just be leaving everything up to DEP. And I don't know that that's in the best interest of the town. Some of the other things that happen is then you revert back to the language that pre-existed prior to 2020-05. And, the one issue with the usable lot area based on your septic area. There's other language that's involved with minor and major permitting stuff that, talk about unintended consequences. We have to go back, we'd go back in time to figure out, well, how did this used to get done? And so it's a really hard thing to figure out if a total repeal is, going to have a lot of unintended consequences or will put us in a better position.
So if we hang on to this ordinance, can people in this area use this 67-7B to build a more reasonably sized home?
Correct. One of the things that was discussed, say for 6073, if they were granted a variance for total lot size and lot width, and were able to build based on the overlay, the town floor area ratio overlay that's in 64-7, they would be able to build to a maximum FAR of 0.45. I believe the information provided by the applicant, they were not able to get to quite 2,700 square footage for their house, but it was around getting close to that number because the 0.45 limited them to a little bit smaller because of the usable land area restriction. But that, when you talk about that provision, that overlay, I think that was adopted back in 2003. That was sort of to address smaller lots and give them more leeway in being able to build, but set a maximum cap of what was, feasible based on the review at that time. You could do something like that to address this issue, but I think what we're all a little concerned about is, what does that look like?
And what's the number that you're starting from?
Right. And so that's the big
45% of what?
the
Yeah.
big conundrum in some parts is, what does this look like? And I think the text amendment that was proposed with a higher floor area ratio, the concern was, well, what does that look like for all these lots where their dimensions are different?
Yeah, you can-
If
And
these were all the same size lots, this would be
Yeah.
so much easier.
Right,
Exactly.
so, that's where I do agree to some extent, we need to do a deeper dive and perhaps bring in folks who can create these images so that we could all see if all the 8 lots on Old Ocean built to a max FAR, what will that look like?
But once again, a consultant needs to know what you're starting from.
Correct.
We're still gonna have to define the land area right here, not with a consultant.
Right, but they could develop different
You know,
scenarios
just
to see what's feasible. But, and to some extent, the applicant for 6073 did that to some extent, but that's based on what their desires is to build.
right.
And is that what's best for the
And I have a
town?
question for town engineer. Seaward of the 79 coastal construction line, can septic be put in that area?
Can you,
on that line.
Say again?
no, I was just getting there so we could hear.
Yeah, so the main setbacks for septic systems are other septic systems and water. So the ocean would be a setback by itself. So the CCCL, I don't think is,
I mean, that's
A
my
setback.
question, is we're dealing with a dune.
right.
So, I mean,
It would be
I
like the
thought I
main
knew
high
a lot
water
about septic
line.
to sewer, but I don't know the answer to that question, and I think it's something we need to,
I would have to research other projects on that.
It's usually 75 feet to water.
Yeah, to water.
from water.
Yeah, even on the intercoastal, it's
So,
that.
again, are we talking about mean high water line? And where does
Another
75 feet cut
fluctuation,
in?
right.
And now we got a 50-foot line, where does it cut into this lot? Now we got a 75-foot line. And we don't have any surveys to, I think that's something
All right, I think,
to go forward, I would like to be able to look at.
I think what I'd like to recommend is what Rick introduced. I think, actually, I'd take it one step further. I think this should be a joint workshop between the town commission and ourselves. Or you,
After some staff work's been done?
yes.
Yeah.
Okay.
I think
that's fine.
it'd be a lot more productive
Yeah.
than having, kind of entities that are maybe not agreeing with each other in the public. So,
Yeah.
Lynn, is that possible to try to set up? And I think, I think we all want to help or address the concerns of those lot owners, but we got to make sure that we do it, in a
We really
Reason.
need some alternatives presented to us that have been researched out. The problem is every time, we can throw out alternatives here, but then they have implications that
Yeah,
need
the
to be
ramifications
researched.
are not clear, so. But I think, Corey, you've done a good job. Your reports are excellent, and I think we may have to have you or arrange for some more visual exhibits that we can clearly see.
And Christie, I wouldn't know which way we were going without your memorandum, so thank you.
Yeah, but maybe Christie and I can work together on bringing something back to you.
Public comment?
Uh,
I know you have to go to work, but it'll only take a minute. Is that okay?
Me too.
All right, yeah, let's
I just.
make it brief there, Terry, please.
I haven't got everything committed to memory, but if you put the zoning map back up, the first two lots that are split by the road are owned by the same owner. And they have a garage and a little living area over there. Whatever you do, since that's the last piece of property that's owned by the same owner on both sides of the road.
Now, are you talking to the north or the south?
No, it's right on
Last one
Anna
to the
Street,
north.
right when you go through the public
Divided.
access to the
Okay.
beach.
Yeah, okay, number
Right
10,
up there.
yeah.
So how would you deal with, and I assume they're separate now with property control numbers, right?
Yeah, I
So
think,
what would someone is going to want to redevelop that property. The wall is falling down. I mean, all kinds of things could go wrong with it. My question is, if it's the same owner, how does that deal with the calculations of lot size,
That's what I'm
and buildable area?
a good question. Let me ask Christie, because my understanding is that if lots are separated by a right-of-way, they have to independently be,
Be reunified.
They would have to, if they're
I don't
going
think
to
you can unify.
redevelop, they have to do a unity of title. And they do get I believe, 1,000 square foot credit
Right.
towards their lot
But we
size.
do not tell them which side of the road they can build on.
Correct.
no.
You are correct.
So in this
Still the
earlier
issue.
discussion, if the person that come in here and owned both sides, he would have a different problem and a better solution? I'm not saying that's what they should do, but
Okay, thank you. Maureen Penny, I know you were a little bit late and missed the
I know,
slot.
I apologize. I 60 seconds or 120 seconds, whatever, I apologize. I just wanted to say that repealing and/or overlay districts I think both have unintended consequences, which we don't want to get into. I think what Neil's suggesting long-term is something we should look at perhaps and do it concurrently with the other things that we are looking at. If you take those 8 lots, one of them is in here for redevelopment right now. 3 of them have already been redeveloped. We only have 4 more. How can we not find something to do on a case-by-case basis that meets the reasonableness standard? These 8 properties have seawalls now. They didn't have a seawall when we were doing all this. We don't have a dune. We have beach and we have a seawall. And everything west of the seawall is their property. So let's just see if there's something we can do to push this particular one along in a reasonable fashion and then look at a long-term proper solution. Thank you.
That summarizes what I was advocating.
Yeah, well said.
That we find a way to put in to our ordinance code, whatever, that if you are landward of an armored seawall, that is usable under the town's definition of
Okay.
buildable.
Mr. Scott, make it short, please.
Thanks very much. Matthew Scott. I'm here on behalf of 6073, the property owner there. It's a little frustrating because what Mr. Hennigan is suggesting is a reasonable solution that would solve many of these issues, but yet you guys are sort of saying we need to get a consultant and kick this can down the road further. The other thing I would just want to add that didn't get discussed at all is, and I wish we had the minutes, I don't know if we have the minutes from the city commission meeting, the commissioners very clearly said they want at the next meeting for there to be brought forward a code amendment that removes the usable lot area limitation. Members of the Planning and Zoning Board said, well, we want to consider that. And here we are, what we're hearing is, oh, we can't consider that today, we can't talk about that at all. When your commission told you to look at that issue and to remove it from the code. And now, and I mean, stop me if I'm wrong here, but that was clear direction that that be brought forward next month as a code amendment. And now what we're talking about is reevaluating everything, and we can't possibly decide this today. So it's a little frustrating to keep hearing this when you have a great solution that makes sense, that solves the problem, and then you're not even considering what the commission asked you guys to do. And so I understand that you're not going to do anything today, but I just want it to be clear that there was direction to look at these things, and nothing is happening yet again.
I think that's a correct statement, but there's a lot of complexity still, how
Understood.
to resolve this, because it's not just your applicant,
Of
it's
course.
for everybody.
Of course. Thank you very much.
Okay.
I understand.
Okay, moving on. Thank you for all that very valuable input. Neil, you're the research center of the, of the world here. If I can find the agenda. Okay, moving on to item 3, discussion regarding signs on the beach ordinance.
So, Mr. Chair, if I may, this is a topic that came up at the Town Commission. It's come up for several years, and the Town Commission has directed for a proposed beach sign ordinance that only deals with signs on the beach to be brought forward. So what is presented in your agenda item is sort of draft language that I came up with between the Town Commission's direction at its April meeting. From a legal standpoint, we can't outright ban all signs on the beach. We'll run into a First Amendment challenge should we do that. Walton County already experienced that. Walton County then created a beach ordinance just for signs. This is somewhat modeled after that. Walton County's was much more restrictive. It seemed at the Town Commission meeting, one of the main concerns was having signs beyond sort of the area between the foot of the dune and the mean high water line, and that the town commission wanted to see signs back towards the toe of the dune. So that's what I've tried to present here. From what I've researched, there's a variety of ways to define the toe of the dune. And so I did find some language that I think might be helpful for the frontal dune. And some limitations which are usually upheld from a constitutional basis, and that is reasonable time, place, and manner restrictions. Obviously, once you start restricting content, that's typically when you'll run afoul of the constitutional protections. So I'd appreciate any comments, concerns, direction, or recommendation to provide to the town commission.
I have a comment.
Please.
The backside page, item B, including but not limited to a survey.
Okay.
Is that necessary, and is it onerous? Do we do that with any other sign in the town?
What I didn't specifically prescribe with that survey was that it had to be a recent survey, because sometimes you'll see in some codes that the survey has to have been made within the last 6 months. So ideally, even if they have an older survey, that would be acceptable. But if you believe that's too constricting to actually require the survey, one of the reasons I did include that was because we have in the past allowed folks to just give a rough diagram of where the sign is going to go, and that seems to have created issues certainly on dealing with beach signs.
We have a changing seafront, you know.
So how often then do you survey? We just keep finding Pandora's box lid, and pulling it open one corner or the other.
Mr. Chairman?
Yes.
I would like to point out that for dune plantings, we do require surveys. So when property owners do come in and request to do plantings on the dune, they are required to have a survey,
Right.
whether it's a survey from when they bought the property or not. And a lot of times they'll request a public record for a copy of that survey so that they can complete that application, and we provide that from our
Yeah,
historical
it's a-
records.
I mean, is there some very simplistic survey that's not, so
Yeah, I mean,
expensive to just do?
Well, in this case, yeah, because you're separated by a road, so it's a much smaller land area to work with. You can get a survey just for that specific area.
You just
It
saying, I
doesn't
wanna
have
know
to
where
all the
these,
meets and bounds, it just has to have
show me where these two corners
what we
are,
call an as-built condition at that time. So,
just to put up a sign.
I think the town has put a couple of signs in that are almost hidden by the grass, warning you that there's a steep drop-off, and be careful you don't go tumble down. At least it says Town of Ocean Ridge on the sign, so I imagine the town put that in.
Are you talking about the signs at Beachway?
I think so, yeah. I
Yes,
think
we
that's
did put
the-
those in, yes.
Can I ask about section C? It says that existing beach signs which do not conform shall be removed within 6 months. Given all of the contentiousness of this, allowing an extra 6 months seems to be
generous.
generous. Yeah, why? I mean, shall be.
30 days, sounds.
Yeah, and then
24 hours.
and then it says a new permit will be required. So is that to mean during those 6 months or 30 days, you have to apply for a permit to get that extension? Is that the intent of the last sentence? A new permit will be required for non-conforming?
So,
Right, if someone has a sign that is conforming, becomes non-conforming under this code, they'd have to reapply to see if they could still have that same sign. Obviously, if it's beyond the frontal dune, they couldn't get a permit, so,
But why are we setting up permits for non-conforming?
if they become I guess the thought was if they become non-conforming by this ordinance, then they could not be permitted. So I guess, I'm not sure what my thinking was at that time.
Okay.
Because
Yeah,
there were
so
so
my
many different.
Is that sentence even necessary?
Yeah, my
Yeah.
suggestions would be to make it 30 days rather than 6 months and strike the last sentence of C.
Just remove it.
Yeah.
Okay.
And if
and
they want
remove
something
this.
else, they can start the process on their own again.
Yeah, you have to give them time.
Is it an issue that they received a permit to put the sign up that they now have? And is that why you're trying to allow some additional time, because it was a permitted sign?
Yes. Normally, when you change your sign code, you set forth an amortization schedule. So the time and money that they spent to put their currently conforming sign in based on a permit, they realize that investment. So a lot of times, the amortization schedule is for bigger signs, for development or a commercial business. So you allow them to sort of recoup that investment, and that's the amortization schedule. And once that runs, then they have to bring it into compliance. So
This isn't a billboard, this is
No.
a sign stuck in the sand.
Yeah, right. Yeah.
I understood, but they did apply for a permit, and I believe there were several iterations of the sign going in.
Okay.
Well, how does staff feel about this?
My only thought would be the reason Christie might put that last sentence in for a new permit required for all non-conforming signs would be that they might have gone non-conforming because they weren't on a PVC or a wood sign, or their size might have been non-conforming. And so now they would be putting in for a permit to make it conforming because of the structure type that it's on or the size.
But how about the question of the 6 months versus 30 days? Because you're going to end up with the enforcement responsibility.
Yeah.
I would ask for 60 days, just simply because 30 days is a very short time frame for us to go out and make sure that any non-conforming signs have now been potentially
That's reasonable.
removed.
That's good.
Good.
Thank you, Lynn.
Item 5, at the top of the page, the last sentence, is signpost shall be PVC or wood or white in color. Isn't that covered by number 4?
Yes.
Well,
Okay.
professionally.
Pardon?
It's nice to have you here, Neil.
I got beaten up by a professional editor for 40 years, so
A lifetime of parsing sentences.
Good.
So strike that sentence,
I think you can strike it.
okay?
That would be,
And we're back to C, the town manager recommends 60 days.
50 days,
Yeah.
not months.
Yeah.
Okay, this is,
Okay.
So,
So the recommendation is for approval with revisions to change it to 60 days and remove the last sentence of that final provision, and then clarify that we don't need the signpost color
I'll make that a
repeated
motion.
twice.
Do we need a motion?
second.
All in favor?
Aye.
Aye.
Wow.
might make-
Okay, just a heads up for I have to leave at a hard stop at 10. So, moving on to item number 4, which Member Hennigan is going to present to the commission and the public that are here. So, Neil, I'll hand it over to you.
Okay, just a little introduction. These changes are proposed to ensure that the umbrella of floor area ratio, the FAR, remains relevant and meaningful. With the evolution of architectural styles, we are experiencing a trend encompassing the use of numerous extensive balconies and porches to circumvent the applicability of the FAR in Ocean Ridge. Oh dear. This is not an argument being made as to the appropriate size or value of the FAR. That may be for another day. These changes are necessary to maintain a FAR consistent and appropriate to its historic use in Ocean Ridge. I do have some comments on, or questions referencing some of the words here, and obviously other people may also, so. Does anybody have any comment with what's in the package? Or anything I can answer?
Sorry, on
or
section
we can discuss?
F, right above, it's on page 3 of 5.
Which page?
3 of 5, paragraph F.
Yes,
All garages or other enclosed areas used or intended to be used solely for parking vehicles. Would a carport that's not enclosed be included if it has a roof? It doesn't seem like it would be, the way it's, the text that's provided, because it's not enclosed.
yeah, do we have it?
Mr. Chairman, that is already in the definition on page 1 of 5. Floor area total as used for calculating floor area ratio includes garages, carports, porticoches.
Yeah, so I just think we might want to have the similar language included on F.
And I have a related question, and that's on page 1 of 5, the very last sentence, and it, and that extend more than 3 feet above the ground surface. That seems to mean that something like a carport, or if you drop it down 3 feet, that it's not going to be covered by this. I'm not really sure why it matters, the elevation of these roofed structures, porches and patios. If they're roofed, the elevation should be irrelevant. Unless I'm missing something. We seem to trip ourselves up with creating loopholes. And the people that are paid to do this figure out ways to build bigger structures on that by
Okay, so
exceptions.
let me just give you a sun porch with a pergola type covering, which is not a roof, above it. So it's got walls that are 8-10 feet high, and then it's got an open lattice covering over the top of it. How else would you capture it for lot coverage?
Maybe I didn't understand what the 3 foot meant. So you're saying anything that has a roof or similar structure more than 3 feet high?
As soon as you put the walls up, you can put the roof on the day after you got it approved. It's no different than
Right.
building,
Okay,
sticking the windows in something that has a
Right.
roof. and
well, I
now it's
agree
a
with what
building.
you're saying. I was reading this as having to do with the elevation of the patio. And, yeah. Or a carport.
Right.
Yeah, we don't want to treat it any differently based on what the slab elevation is.
I agree.
And I'm a little nervous about the word porch, unless we have a very good description of what a porch means. They'll say, oh, that wasn't a porch, that's a covered patio, or that's a lanai, or that's a, we have some other, what was the recent one that was in here, a loge, or?
Well, there was an exercise room.
Loge, yeah.
We had an exercise room.
This isn't a covered porch, this is a loggia.
Yeah.
And an exercise room, yeah.
Yeah. A breezeway versus a porch, I mean, that's.
So I'm looking at the memorandum from Christie, and you're describing this for us, right?
Pardon?
Yeah, it's all based on Christie.
Yes.
Mm-hmm.
I saw no problems with any of this.
I mean, Christie, I have a question on 2 of 5, B, number 3, where we're talking about other enclosed areas used or intended to be used solely for parking vehicles, building access, or storage. I don't know if that is the words I've got here for myself are, I don't know if this is comprehensive enough to convey that what we're talking about here is non-habitable structure. Rather than trying to list what all those things were, when the intent here is that anything that's supposed to be frangible can be washed away, should be considered non-habitable. Is that right, Mark?
Non-habitable, correct?
Yes.
Yes.
So is there any way we can work non-habitable into that?
Yeah.
Okay, I had, this will show my ignorance of how the FAR is calculated. Is the FAR calculated on the lot size or on the usable size today?
That's what,
That's what-
and
It's both.
Manny, it's been done both ways, hasn't
It's
it?
both ways. Manny, you wanna come, man, come in.
Manny Palacios, zoning guy for the town of Ocean Ridge. You're right. It's basically, right off the bat, unless there's something specific, it's the lot size. But under our code section, it used to have as usable land. So right now, it's just gonna be the lot size. 36%, unless
Yeah.
it's over 20,000 square feet.
I've got a couple of examples here, and I want you to kind
All
of
right, go
talk to them. I'll talk my lot. I have an AT&T easement that's 10-foot wide that straddles our property line, so 5 foot's on mine. And if you used usable in your definition, then my setback has to come from that easement line, or my FAR calculated less the
I don't
5 foot times the property length?
I don't see anywhere in our code that tells me I have to use your easement, unless you're building something right on it.
Okay.
I don't have a setback set for that. So according to what I have in our code, it's just from your property line, unless you're putting something up near the easement line, utility line. I think there we require some sort of
But I was reading in here that usable area seemed to take these easements out. Is that what?
No.
No?
no, it's
I
gone.
just read it
No.
wrong? Okay. Because the other place that this comes up is that we've been trying to encourage people to grant us drainage easements. And if we start subtracting that land area, we'll never get any help in getting these drainage easements.
I can only go with what I have in front of me,
So right now, the FAR is calculated on the
the lot size.
lot size.
They complicate.
And that's what's proposed going forward, Neil?
It is in this context, yes.
Okay, thank you.
Yeah.
You're welcome.
No, it's always historically been that. Except if you have a easement.
So Roger, I have a question for you.
Okay.
3, 4, 5, go back up to number 6. And go up to the sentence, the last sentence, the floor area occupied by roofed porches and balconies shall be exempt, ...
Sorry, I haven't found it yet.
Say that again, the reference.
Which page number, please?
4 of 5,
Okay.
the floor area occupied by roofed porches and balconies. So if you parse, you see that's the last sentence in number 6?
Yep.
Okay, so if you parse that sentence, does roofed refer to porches and balconies, or is it roofed porches and all types of balconies?
Since it says and rather than or, I would read it as saying you add together roof porches and balconies.
So if you had a balcony and didn't have a roof, would you be including it or not?
Yes, because it
Yes.
says roof
Yeah.
porches and balcony.
And balconies?
Yep.
Okay, that's the intent. All right, thank you.
On page 1 of 5, middle of the page, bold heading floor area total, and down to the next, almost the next to the last line, it says basements, comma, attics, paren, unless used as living space behind attics. I think if that's the intent, we should have the same paren after basements also. So it'd be basements unless used as living space, attics unless used as living space. I don't know that we treat basements any different than attics about living space. We don't, and we certainly don't want to create a living space exception here.
Right.
Yeah.
So just basements, get rid of the common and put in and
It,
attics?
That's somebody who's a better writer than me. I was gonna just put the paren twice, once behind basements and
That's the same.
once behind attics, and make it real clear,
Fewer
although
letters.
slightly redundant.
I don't think you need to use the parens. I think what you suggested is you could say, not including basements, remove the comma, say, and attics, and then take off those parens unless used as living space.
Good.
Yeah, that would,
So the purpose here is just to make sure we're more consistent in our,
clarify, re-clarify.
Yeah.
Yes,
we're not changing
No,
the
not
FAR.
not changing
no,
the
no.
FAR.
No,
Just out of curiosity, why would you exclude a basement from the FAR? Because, just because I say I'm not going to use it as a living space, all it takes is me moving in to convert it to a living space.
Well,
actually, that's a very good question, because we had an applicant here that had a massive basement. It was 4 cars primarily, but the dune allowed it to create a full basement. So,
I understand.
That could be
but it's
converted.
Currently, right, as I understand it, basements are exempt from FAR. Is that correct, Manny?
No, the garages are part of the fire.
No.
Basement.
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 Basement, I'm sorry, yes, they're
Right.
not included.
So they're currently not included. And how we'd be just adding is, okay, if they're not included, we at least want to include them if there's living space.
Yeah, but you have no-
But the problem is, of course, changes that get made later.
yeah, you have no control.
Now, basements aren't a huge issue here,
Mr. Chairman?
but
Yes.
there's some cases.
I'm sorry to interrupt. We recently had a pre-application meeting with a property owner that is interested in building, I don't recall what street it was on, but on pilings with the first finished floor elevation at sufficiently high above the current grade that would allow parking underneath and a sort of an open covered porch patio area, if you will. I guess my question would be, how would that be included, or would it not be included, do you think, in the definition as you're discussing it today?
Well, that's the issue.
That's the kind of question we turn around to you, Corey.
And
Maybe
we're
the
gonna
other
face
question
that-
would be, do you have any intent, would the intent of the planning commission be to include calculation of that space as part of the floor area for FAR?
And just to point out, I mean, we're gonna face that more and more with the finished floor FEMA conditions. So,
Well, that goes to my use of the word non-habitable. if it's non-habitable, should it be included in FAR?
I don't think so.
No.
Well,
Yeah. So it's not hand,
if you build one of these lower levels, and when it's originally constructed, it's open mainly for parking, and then a year later, you put up a cinder block walls, and it's now habitable. How do we deal, I mean, do you have to get a permit for that, and the permit gets denied? Or is a permit not required for putting up cinder block walls to make something
you do
habitable?
require a
Any
permit.
change to the approved site plan requires a permit. And
Yeah.
if you're putting walls up, that would definitely require a permit to make
Any
sure
improvement.
you're not
That's-
compromising the structural stability of the existing structure.
So if that then made the floor area larger than was required, the permit would be denied.
Exactly.
That would be,
The hoped for result.
Yeah, the one thing that, what Corey was describing, if it's parking underneath but it's open, it wouldn't be defined as a garage, and they're getting more FAR space in the rest of their house because they didn't build a
Yes.
garage, which is part of the FAR.
Right.
So there's always kind of unintended consequences.
right.
But right now, we're just gonna deal with this, right?
Right. Till that comes.
Till that comes.
Okay, no, I think all in all, this is,
So I have one last question on this. What do we do with the definition of floor area ratio that's based on usable land area? In the definitions,
Is that getting back to my questions to Manny?
yeah, I mean, it's.
right, because when you go into the zoning districts, like 64-1, if you look at how it talks about floor area, it's based on, your calculation is based on lot size, but in your definition, the actual calculation is based on usable area.
Yes. That's,
So should the definition for floor area ratio just be changed, so instead of usable area, it says lot size?
That's the traditional way,
Is usable area.
usable area, yes.
What are we doing with
No,
these?
no, I mean, lot area.
Lot size.
Lot size, lot size.
You almost trapped me there.
well, that takes us back to the coastal lots again.
It does.
It does.
So,
So let's use lot size.
Except for coastal lots.
No, I didn't know
No, no.
exception.
No, coastal lots, because of the CCCL line,
We're okay
yeah,
at the moment.
yeah, I mean, that's a state.
Okay.
You don't technically own it. You pay taxes on it, but you can't use it. No, I think leave it as a lot area, please.
Not usable land, but lot area.
Yeah,
Now,
it's a lot clearer.
One thing that came up earlier, I think it was Penny who brought it up, talking about the fact that those 8 lots now were armored, and that extended their lot area out to the armored. I'm a little concerned about, and you said they all have it now, but there probably will be other lots that want to armor their lots. That seems to be ubiquitous in the United States. So that would be a way of people expanding their lot area just by coming in and armoring
I guess that's something we have to accept.
you have to justify, though, you have to justify armoring. It's not something you can just decide to do.
No, DEP's not gonna let you take the dune, there was no dune there, they had to armor so that they didn't lose their property.
Yeah.
okay, so that was,
I have a dune.
so that was the issue with those 8 lots. they didn't have a protective dune.
No, they were.
Okay.
very
They were
vulnerable.
sliding,
Oh, all
sliding
right.
in.
Slide into the
The
ocean.
way you presented, I missed it. No. Yeah. Got it.
So are we gonna say, change that from usable land area to lot area,
Lot area,
Lot size?
lot size.
lot size?
Well, we don't define lots, well, we, is lot area a definition?
Christie will make sure it is.
Let's see.
Yeah, I think everything's.
And
area.
not using the word lot size? Because here it says lot area means the total horizontal area included within lot lines.
That is the definition under the code.
Definition
yes,
is
sir.
Pardon?
That is the
Area.
definition under the code, yes.
For lot area.
Yes.
Area.
So I think we should use that, not the word lot size.
Yes.
Lot area.
Okay,
Lot area.
We'll then have to go correct that change in 2020-05 that describes lot size and usable land area.
Yeah,
Then go through it all again and make sure that there are no unintended consequences. As Mr. Carey keeps reminding me.
We couldn't do it without you, Christie.
Do you want me to work with Corey on the actual ordinance language and bring it back for one final review?
please,
Yes, please.
Okay.
please.
Okay.
We don't guarantee that we won't have some comments.
That's fine.
Okay,
Move for adjournment,
please.
unless somebody has comments.
I just want to again thank Christie and staff for doing a great job.
Thank you.
our hired guns.
Okay, we have a motion for adjournment.
I move we adjourn.
I second.
All in favor?
Aye.
Aye.
Thank you.
I want you to know I protected all of us by bringing my umbrella.
Thank you.